supplementary cause list, item number 1 for pronouncement of judgment.
There are two petitions. Similar subject matter is the same.
Yes, ma'am.
So this court has passed a common judgment. I'll read you operative portion. All the parties are here.
Sure.
In view of the observations made above, this court finds that the impugned orders in both the two sets of petitions have been passed by the concerned court without jurisdiction, and the same are liable to be set aside and quashed, which is done so herein. The prayer made in these petitions here accordingly allowed.
Obliged.
May I please, Your Lordship? I beg to mention item number 19, Your Lordship.
Huh?
Number 9.
Lordship, if I may please, Your Lordship. Lordship, this matter has already been part heard on the last date. Lordship, this is a 376 where that man was beaten up in the truck stop, and both parties have a thing, but then the petitioner wanted some time to research.
Yes, Your Lordship. We require some more time, Your Lordship, to prepare.
19.
Yes, Your Lordship.
I thought 9.
19.
19, Lordship.
I was wondering why. Oh, appeal.
Yes, Your Lordship.
So how long?
1 week, Your Lordship.
On pre-made by the appellant? This is matter to 1 week.
Highly obliged.
Yes, Lordship. I beg to mention item number 12.
Well,
After
this is a 2019 matter, Mr. You are for whom?
I am for the Union of India in this case. So this
has a very limited role in this matter.
Yes, what's this matter about?
this is the for the teacher of the school.
Rifles.
It is situated in the army area, so it will be seems to be similar situated Assam rifle matters like that. So you receive this from the school. I tell them this either they have to give the authorization, but nothing has come forward if I appear. So as the Union of India, I cannot appear for the school. So I request them to either to authorize me.
But have you, steps have been taken?
No, they already filed this affidavit also here. They filed. So
Through you?
Not earlier, before hand over the case to me.
Then who has appeared?
So I think filed by the earlier council for the Union of India.
Who's the...
So maybe they have authorized, but I am not sure. But I believe that if I appear on behalf of the school, then authorization my separately is required, because I cannot represent them as a Union of India.
Yes, you cannot. You may not. But then...
So I tell them that if they give the authorization to me separately, and if there is no conflict, then I can take up. So I think there is no conflict, but otherwise also I have to take my power.
But earlier you had, on behalf of the Union of India, the CGC has appeared.
So when this case is handed over to me as a CGC, I am appearing. So others is not appearing. So I find that I should take this power from the school if I appear on behalf of them. Otherwise, it will be wrong on my part.
Honestly, but then...
So otherwise, they can even appoint another lawyer.
Since 2019, this matter should have been settled.
Just a price. Earlier, affidavit was filed by the earlier CGSC, and they continuously appear. After that, the CGA also appearing. Perhaps he wants to say that Union of India is not together with the school management, he should be represented differently. Therefore, perhaps he is trying to approach them to get some more clarification, my lord. I have no objection, my lord. Let them take 2 weeks or 3 weeks time to clarify this.
4 weeks, you see.
On prayer made by the Leonard CGC appearing for the Union of India, seeking some time to seek instructions and clarification in this issue as far as the representation of the matter is adjourned. This is still after 3 weeks.
Operate.
May it please your lordship, I beg to mention item number 13. The Learned Counsel, Mr. Pubin is out of station, your lordship.
No objection, Lordship.
On prayer made by the petitioner on the ground that the conducting counsel is out of station, the same not being objected to by the respondent, matter is adjourned. This is still after 1 week.
From supplementary cause list, item number.
Yes, anything else? Be fast.
May it please your lordship. Lordship, I beg to make a mention of item number 329, your lordship, which is a connected matter. The senior conducting counsel, Dr. N. Mozika, needs some time to prepare this matter, your lordship. I pray that this matter may come up after 2 weeks, your lordship.
2018 matter. Are these school matters or
Yes, your
Lordship,
lordship.
yes.
School teacher matter, your lordship.
same school?
Lordship, same. Some is alleged non-payment of salary. Some cases termination from service.
See, it appears the matter has been part heard. So
Yes,
now
Your Lordship.
you have to start over again. Letter counsel for the submission has been made. Prayer has been made on behalf of the petitioner, seeking adjournment on the ground that the Leonard senior counsel, who is conducting the matter, is not is personally indisposed. On the same not being objected to by the respondents, matter is adjourned. This is after 1 week,
2 weeks, your lordship.
2 weeks.
Obliged, Lordship.
Much obliged, your lordship.
Supplementary cause list, item number 2.
Lordship, we have received a comprehensive report, lordship. If I may submit this to the honorable court, lordship.
Have you given him copies?
I don't have a copy myself, lordship. We received it just now. So sorry, lordship, because it came from Jowai just now.
Cannot be. This is not how you conduct yourself before the High Court.
Apologize, lordship.
You get it photocopy, give it to. We'll take at the end of the board.
At the bottom of the board, lordship. Much obliged, lordship.
From daily cause list, item number 1.
My lord,
was required.
I'm filing in the course of the day, my lord, the affidavit. I just got the signatures and everything yesterday.
All the other,
Respondent number 7, my lord. I'm afraid.
Lordship 125 has filed, Your Lordship.
your file, counter.
125 will only file an application questioning the maintainability of the writ petition.
That is what we are also filing the same application, my lord. We are challenging the maintainability of the writ petition itself, my lord.
This matter is not listed for admission hearing.
Not yet, ma'am. My lord, we'll see the last order. $13.9, my lord.
European Court 767.
Yes, so what do we do?
Well, I'm filing in the course of the day, my lord. The objection, my lord.
So we'll list the matter for admission hearing.
My lord.
My lord, I'm appearing on behalf of respondent number 6, Your Honor. Your Lordship, kindly grant us 1 week's time. The affidavit, we just require time for opinion.
When you do it within the next date fix, with it, advance copy to the petitioner, the matter will be posted for admission hearing. Then a counsel for the respondent number 7, number 6, I don't know, 6 has submitted that to respond to the petition as regard the issue of maintainability could not be filed today, and some time is prayed for the same to be filed. Similarly, a similar prayer is also made by the respondent number 7. The prayer made is allowed. The said respondents are to file the said response within the next date fix with advance copy to the petitioner, who may respond to the same if so advised. This matter is now posted for admission hearing on the next date fix. This is after 1 week.
Obliged.
Item number 10. Item number 10.
Please, Your Lordship. Well, this is a matter concerning the relief and the rehabilitation colony of Shillong. Sir is on his way, no?
Yes, Your Lordship. Yes, sir.
Yes.
Please, Your Lordship. Lordship, if this matter can be taken out at the end of the board, Your Lordship. My senior is on his way, Your Lordship.
Everything, all the matters are to be taken at the end of the board. So we'll go the reverse.
Your Lordship, if I can just call him and then ask if he's almost here, Your Lordship.
So end of the board.
Much obliged.
Item number 11.
Goodbye.
Yes, Mr. Karola.
Yes, Lordship.
What is
Lordship,
your
the thing I've just received the order just now, only, Lordship. Matter has been disposed of as withdrawn, Lordship.
That order may be. I have not seen the order. So if it's withdrawn, this will become infructuous.
Give him a copy.
Lordship, I'll produce the copy. I've just received it on my thing.
Yes.
No, the private respondent is supposed to produce it. It's their withdrawal.
Oh,
Order has been passed by the council. They have to place the orders. The council has to place the order.
yes. No, you are appearing for the.
Private party, Your Lordship. For withdrawal, now they have passed an order.
Where is it placed?
Bring that on record.
No, but if it has been passed, then it can be disposed of. We need not bring it on record that way. We can just hand over a copy, and that can be placed.
Yes, that's
So
what I
we have
said.
a copy. If Lordships take it up after a while, we'll place it on record. At the end of the vote, we'll place it on record.
On their statement, my lord, it can be disposed of. We
Yes,
don't wait.
exactly. That's what. Show me a copy of the order.
We'll place it on record in a while. Lordships, yeah.
Lordship is here. That's fine.
Which is one? This is 37 and 35. 37, yeah. Is it part of the same thing? 37, 35. 35 relates to which writ? See, give the file.
Dispose as withdrawn, last line.
There are two writ petitions, no?
226 and 226 is with regards to.
So, Mr. Nobri,
37.
Yes. So
you will withdraw this petition, simpliciter.
my lord, they are now rendered infructuous. Be disposed of as infructuous.
So, Mr. Sen, you're appearing for.
Respondent number one.
You are the
Respondent
relevant.
number
You are the relevant respondent.
Lordship. The Facilitation Council, the respondent number 1. No, this is 37.
And you are who's respondent number 2?
This item one.
So you concur with this
Lordship, this was an instant that we had gone for
at your instance. Heard letter counsel for the parties. Mr. You're appearing as GA, Mr.
Senior GM.
No, you're appearing as government counsel.
Yes, yes.
No, you can't appear. This is a
So they
counsel.
appointed us from the thing only, not a special counsel.
He'll require to appear as SN, my lord. It cannot be a government
I have
counsel.
no difficulty, but
This
they had
is a
appointed the
statutory
government
body.
itself.
It's a statutory body.
That's why I.
Whatever.
SN.
I have no difficulty with this because there was no appointment letter as a special counsel. That's the only reason why.
But Mr. SN letter counsel appearing on behalf of the respondent number 1, as well as Mr. M. L. Lupure appearing for respondent number 2. Mr. SN has brought on record copies of the relevant orders dated 22/9/2023, wherein by the said order, who has passed this order?
One of the council, Meghalaya Micro and Small Enterprises Facilitation Council. It's a statutory body, my lord.
Lordship will find in the first page, right on top.
The Meghalaya Micro and Small Enterprises Facilitation Council, on consideration of the dispute between the relevant parties, particularly the respondent number 2 herein and the petitioner, has in essence dispose of the same on the complaint. Do you call it a complaint? No.
Claim.
On a claim. On the claim being withdrawn. And what was this second order? This the other one?
There are two writ petitions, will
Item 14 and 15.
Okay. So same order would
There are two proceedings.
Yes,
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 one is 35, one is 37.
So, respectively is with 37.
without going to the merits of the matter, the learned counsel for the petitioner, Mr. Liman Nongri, has submitted that by the said order dated 22/9/2023, the grievance of the petitioner has been attended to, and as such nothing survives in this petition or agitation. It is therefore submitted that in view of the said aforementioned order, this petition may be disposed of accordingly. On consideration of the submission made, the said order produced by the court today is taken on board. The same shall be marked as Annexure X and will form part of these records. Next, on submission made, the petition herein is hereby, it would have become infructuous then.
No.
Hereby disposed as infructuous. Petition disposed of.
Khali plate.
So the
Similar order for both
same
matters.
Item number 16.
Yes, what is required here?
This is fodder scam. This is fodder in the flash flood, my lord. That is the matter.
No, what
So
is?
I have already argued.
You have argued. What happened? What is to be done now?
Your Honor, we would like to give some submission here, no, regarding the transaction.
To start,
My senior is on the.
there are two cases.
There are two cases. Both the cases are in respect of the fodder allegedly supplied for flash flood in the compound, cattle compound, etc. There was no compound. There was no. So that was a disputed question of facts, my lord. Your lordship would recall.
See, Mr. Kumar, looking at the facts and circumstances of this case, you are equally at fault.
And I can't, because my officers, your lordship, for 14 days after 4 months, my lord, in 2014, and they say that 2 crore rupees, 3 crore rupees, 6 crore rupees of cattle feed have been supplied. When we inquired where have you supplied cattle feed, initially said that we have supplied it to the villages because it was far off places. Then we said that it is not as per the statutory norms. Then the reply came from the district veterinary officer, no, we have set up those camps also.
Have you independently made any departmental inquiry?
That should have been made, my lord. The question is that is not made, whether they will get the right on that basis.
That apart.
Because if the lordship made, I have no issue, my lord, if your lordship notice, and I have also noticed that this is a public money, where in public money this kind of collusion is taking place with the government official and the contractor. Who should benefit it? That is because it's apparent on the face of it, my lord, that there was no cattle camp, there was no supply. The supplies orders are not meeting the norms laid down by State Disaster Authority under the Act. If the statutory norms are not being met, my lord, whether the contractor after 7 years, 2014, how do I verify now? 2014, 8 years, my lord. And then they say that, look, there was some order by district veterinary officer who has no authority to pass those orders.
In a sense, that becomes somewhat of a disputed question of fact.
It's a disputed question of fact, my lord.
If I may only submit.
It's a disputed question of fact. After 8 years, limitation is gone, everything is gone. Where do I can prosecute that officer? Officer may be retired also, my lord.
They have done it.
That is exactly why I submit, my lord, that the work order was issued in the year 2014 by a particular officer. Assuming that there was a collusion as stated by Learned Senior between that officer and the petitioner here, why is there an affidavit filed in the year 2023 by the department now from a different officer saying that no, this was done? Whether, my lord, it is for whether the petitioner who has supplied the order as required should be prejudiced just because there is a dispute or a so purported dispute sought to be raised between the two government agencies, my lord.
See, Mr. Dev, yes, that's correct. But the fact remains that
and here it was not a question.
Nothing on record is shown as to whether it has actually been.
No, it is there, my lord. It is there. It is there.
There's nothing.
If I may just take a lordship, I will not submit anything on the laws and all. My seniors have argued only on the facts, my lord. Because crucially, in our writ petition, the district, the animal husbandry department has filed a very specific affidavit. What had happened, my lord, the same objection was raised when the matter was before the other bench, and we had pointed out that there's a conflict between the department. So the other department, which is the animal husbandry department, should clarify that whether, because they were the nodal agency at the time of the supply and the work order, and they have clarified, my lord, that the work order was issued. It was issued pursuant to a meeting held across amongst all the stakeholder departments. A rate was fixed. The supply order was issued. There was a confusion as to whether the supply was made directly through the village headman or through the as per the rules. That was the confusion. The confusion was clarified by the department, saying that it was done according to the rules and not done haphazardly or directly given to the headman or whatever. And they have even given the list that which camps have we supplied.
See, that is also a disputed issue because now somewhere it is said that there are camps, somewhere it is said that there are no camps.
No, it is said that there are camps. There was a confusion earlier where they thought it was supplied directly, not through the camps. That was clarified subsequently through their own departmental communication, and which is very much evidenced in the affidavit. It is a very categorical affidavit. If Lordship only takes that affidavit, that would clear out the picture. If Lordship has the affidavit in WPC...
No, now what is required to be done? Sorry, we have gone off track. What is required to be done now?
Well, if I recollect, Learned Senior had made certain submissions.
No, the state, the respondent have concluded their argument.
So maybe, sir,
okay.
Make a rejoinder.
Your Lordship, my senior is not here. He has a medical appointment at 11.
Just now he was here?
Yes, sir. Yes, Your Lordship, but then at 11 he has a medical appointment.
So I just wanted to place this fact because in their matter, this affidavit is not there. So this affidavit, yes, this affidavit is very essential for adjudication of the matter. As to what exactly is the dispute, because just for the sake of raising a dispute, they cannot raise the dispute at this stage.
We'll take up this matter today.
The issue is, my lord, your lordship has seen the letter. When the authorities, they submitted the bill, authorities made the inquiry that did you set up the cattle camp, etc. They said no. and then thereafter they realized that without cattle camp, they will not be entitled under the statutory rules, then said that, oh, it was inadvertent confusion. Confusion is a word which is very easy, my lord. It can cover all my misdeeds, omissions, etc. And then I have to pay for what, my lord? The whole order, if your lordship would see, flood was for 15 days in September. Orders are being placed in January and February. Flash flood will be flood for how long? In January, February, your lordship knows, and we are also aware that there is no flash flood. Now, on these foundational facts, they are coming before your lordship and invoking your lordship's writ jurisdiction. It's a pure and simple disputed question of fact where they did not have any material. If they were having material, they would have gone to the civil suit, recovered with the interest. Writ court can't be used for the purposes of recovery of money, my lord. And some collusion is there. I am not at all. And those affidavits will say collusion. So collusion only, my lord.
We'll take up this matter on 5th then.
Yes, sir.
It would be better to hear both your matters.
I just want to make a few factual submissions.
You can do it. As agreed to by the parties, list this matter on 5th.
Item number 18.
Please,
Yes,
Lordship,
have you got it?
it's coming right now, Lordship.
my only prayer here is, my lord, on the basis of the fact that this lady is suffering from HIV for the last so many years, from 2008. And my lord, whether her being in prison, whether she will be able to be treated properly or not, that's the only thing, my lord. Of course, on merits, I don't have much to say. I candidly concede. But also taking into consideration the judgment I placed last time, my lord, Bhavani Singh, which lordship himself had relied upon, in a same case for the same lady, which involved intermediate quantity. Now, my lord, the case may be serious, but the fact remains, my lord, bail was granted in that case also only on the ground that she suffers from HIV positive. Now, my lord, there may be a more serious case against her, but the fact remains that, my lord, the court was concentrated enough to understand that this lady, who has been suffering from such a serious disease for the last so many years, may not be given proper treatment inside the jail premises. On that count, lordship was pleased to enlarge this accused person on bail. So that's the only thing I submit, my lord. More than that,
Is she a confirmed user?
She used to be a user, my lord, earlier. That is the reason why she got this HIV thing.
Invariably, it happens. If you're a
That
user,
is how they. On merits, I don't have much to say, my lord. I'll fairly
What is the
concede.
stage of the case?
Just charge sheet has just been filed, my lord. I don't think the charge has also been framed.
Also, I have to seek instructions regarding that. But then, lordship, as per my instructions, she's getting proper treatment, lordship. She's getting the antiretroviral treatment, lordship.
HIV treatment, my lord, is something totally different from any other disease. There is no such cure till today, my lord. HIV is something, my lord. Anything can happen to her, my lord. Internal organs may fail. Anything could happen, and it's not just that she's suffering from HIV recently. She's been suffering from the year she was from 2008, my lord. So it's been almost 15 years. Lifespan of person suffering from HIV becomes quite less, my lord. They are immune compromised. The immune system is not as robust as it is for ordinary people. Keeping the person in prison. Because, well, admittedly, my lord, I have made a very fair submission before this court that I am asked to bring medicines, my lord, which means that, they are not taking good care of me. Only after a direction when this court was given, she was taken for treatment.
Maybe
it's very,
lordship,
very
those statements cannot be accepted by court since the same is not made in the pleadings, lordship. If my friend wants to submit this, make such submissions, lordship, we can bring it through an affidavit and we'll reply to that, lordship, because as per my submissions, we've been giving proper treatment, lordship. We've been, and as per the Supreme Court's judgment, lordship, to provide free treatment for HIV positive, lordship, and that also, and that judgment also extends to private hospitals also, lordship. Hence, from our stance, lordship, we've been giving the proper treatment, lordship.
If that is the case, then why is she made to pay for her medicine?
Exactly, lordship. That's why I'm saying if those statements cannot be accepted at the bench, lordship.
It is a fact, my lord.
It is not fact, lordship.
On affidavit. That is an application for a
If
liberty
it
of
is
an
as a fact, lordship,
I don't have to
the
plead
petitioner
everything in the petition,
shall bring
my lord.
such evidences to substantiate that submission. Lordship, the prescription for the medicines,
It was recently in the newspapers, my lord is privy to that also, my lord. This is happening everywhere. They're not supplying medicines. They're asking their, my lord, relatives to bring the medicine, especially in such serious cases, my lord, anything can happen. Of course, my lord, the case is a very serious, the allegation is very serious against me. Even though there is no direct evidence, rigors of 37 will apply. I fairly concede I don't have much on merits. But I'm only arguing on medical grounds, my lord. It's a very, very serious disease I'm suffering from. Something which till date, there's no cure for.
And may bring to your lordship's notice that this woman has been alleged in many FIRs, lordship, lots of many cases where investigation is pending against her, lordship. And there was a judgment of Punjab, Haryana, which was passed recently, where it states that the rigors of 37 will be more stringent when
I read it. Anyway, you have a list of the cases she's involved in?
Lordship. As of right now, I don't. But as of right now, I just have this and.
Granted bail in the other case, then I'm arrested in this one.
Lordship,
that's what I know.
But then also, lordship, that makes up multiple cases against her, lordship.
Who will not exactly be the definition of multiple, my lord? Multiple would be more than two. That's my humble submission. No, I'm not even arguing, my lord. My learned friend has to understand. I'm not arguing on merits. Well, I'm fairly conceding it's a very serious allegation against me. Rigors of 37 will apply. I say that. But I am only arguing on the medical aspect of this person, my lord. They have not been able to give me proper treatment. They are asking my son to take medicines all the way from Shillong to Cleriad every now and then. It's a very serious disease.
That's a disputed fact, lordship.
Look, I'm arguing a bail application where the question of disputed fact will not come. But had it been a very simple ailment, my lord, I would have fairly considered no, my lord, my bail may be rejected. But my lord, I am a HIV positive patient for the last 15 years.
And we, from the state, we're giving up, as per my
No, you're
report,
not
we're giving the
it's very, very apparent.
treatment
My lord, the
lordship.
last medical report which lordship called, my lord, a one-page medical report was given. My lord, as if I am not even a human being. Just because I am accused of a very serious crime, my lord, they should not send a medical report like this. And subsequent to lordship's interference, my lord, at least some medical tests were conducted, my lord, and I doubt whether they will do it later also. This has happened to a lot of, my lord, under trials. They are not giving proper treatment anyway.
Then we should file a PIL.
Maybe I will.
This is Gautam Lal, counsel for the Commissioner. Also heard. Ms. Silla is not here? Or
Lordship, as per my information, she has a meeting with the chief.
also heard Mr. A.H. Karwalang, that additional senior appearing for the state respondent. The medical report in respect of the accused Srimati X has been produced before this court, and on perusal of the same, it appears that the history of the treatment given to the said accused person has been detailed. There is no dispute that the said accused person is suffering from HIV positive. And is undergoing treatment for the same. Though in layman's term, it can be understood that treatment for HIV patient is not exactly treatment per se, but prevention of the patient contracting any ailment on his or her person which would aggravate the situation as far as the patient is concerned, for which special treatment or special treatment is required. There is no doubt that the correctional home, that the prison and correctional home authorities are doing their best to ensure that the patient is being looked after even while in custody. However, it is also equally valid to say that the person suffering from such person who is undergoing such procedure is not only physically depressed but also mentally depressed. It is also tried law that in cases involving narcotic drugs and psychotropic substances, especially involving commercial quantity, involving seizure of commercial quantity of such contraband, the rigors of section 37 are mandatory. Rigors of section 37 are to be complied with and applicable to the case. On the other hand, there are also provision even for this court to take refuge to the provision of Article 21 to say that the life and liberty of a person is equally important. As the case referred to by the direct counsel for the petitioner, that is the case of what is that case? Bhavani Singh versus State of Rajasthan, 2022, SEC Online, SC 1991, has demonstrated this aspect of the matter, wherein the Honorable Supreme Court this is also a case under NDPS.
Well, I am not aware about what is the nature of this case.
It doesn't look like. Wherein the Honorable Court, in a case for application of bail, taking note of the fact that the accused person therein, involved therein, is a person suffering from HIV, and on this premise had granted bail. As observed here and above, the accused person is indeed suffering from HIV, irrespective of the fact that the treatment given by the state may be adequate or not, as the case may be. This court is of the considered opinion that special consideration be given to the accused to get proper treatment or to recuperate from her suffering in an environment congenial to her. It is needless to say grant of bail is not the end of the matter. It is only to ensure that the accused shall not abscond. If the accused person would cooperate with the investigation and the trial, the purpose of the criminal proceedings would be served.
May I please, Your
Upon these considerations, the prayer of the petition is prayer of the petitioner. Herein is hereby allowed. The accused person, Srimati X, is hereby directed to be enlarged on bail on the following conditions: that she shall not abscond or tamper with the evidence and witnesses, that she shall not leave the jurisdiction of the state of Meghalaya without prior permission from the IO or the court concerned, that she shall furnish a personal bond of 1 lakh along with one surety of like amount to the satisfaction of the IO or the court concerned. Violation of any of the above mentioned conditions would allow the prosecution to take necessary steps for cancellation of the bail.
May I please, Lordship. Lordship, if the condition stated in paragraph 5 of the Bahawani case, Lordship, may be imposed for periodical reporting to the...
Yeah, she's facing trial, so she will...
Periodical?
Appearance before the concerned police station, Lordship.
No, that has been said. That has been said. She is to report before the IO. She is to report if the case is, finally charged and, has gone for trial. She is to appear for the court concerned.
Gone for trial now, so she'll appear before the court. Normal course.
This is a question of bail. If she fails to, then you are at liberty to get it cancelled. Thank you.
Second call from daily cost list, item number 1.
State has got limited role here. State entire.
So this is with the issue is the jurisdiction of the Dorvashno.
No, well, the issue is that the district council, my lords, has issued a letter whereby they have subjugated us to a certain Dorvashno. Now, that particular Dorvashno, my lords, way back in 1981 or somewhere in the late 80s, my lords, there was a conjoint meeting by all the three parties whereby they have said that our jurisdiction is this, Umpling's jurisdiction is this, and you are not within either of our jurisdiction, so you will have your independent, distinct identity. Now, that position maintained. Now, thereafter, my lords, there was also another round of litigation before the Honorable Guwahati High Court. Certain directions were passed, and, my lords, there is an interim order staying the resolution of the district council, my lords, trying to merge us with a certain Dorvashno. Again, now the same issue has been reiterated, my lords. In 2019, again another notification has been issued by which again we've been asked to be merged and brought under the jurisdictional control of the Rinja Dorvashno. That is the issue before your lordships. Shnong is not here, no? Well, there's one issue, my lords, before I open up, I have to bring to your lordships kind notice. Well, earlier Miss respond number, the Shnong, my lords.
Yes.
Respond number 7, that's the Dorvashnong Rinja.
Yes.
They were represented by Miss N.G. Shila, my lords. Of course, after Miss N.G. Shila had become a government counsel, so she had recused herself from the matter, and your lordships had directed us to take fresh steps on the respond number 7. Steps have been effected, my lords, but there is no representation before your lordships today.
They are the main stakeholder.
Main stakeholder, but the
process.
But the cause of action emanates from you.
Yes, it is their letter, my lords, which is under challenge before your lordships.
Admitted.
Of course, they would have a say as to whether they oppose it or or complied or rather consent to it. But
this is a ticklish issue, your lordship. Para 20 of the schedule will have to be gone into to understand the areas and jurisdiction of this particular colony. Whether it's under the tribal areas of the state of Meghalaya or whether it is any other area. That is an issue which need to be...
I don't think so there's any dispute with it. Para 20 would apply, my lords, and Para 20 we are within the tribal areas.
Geographical issue would not come into...
Absolutely.
If we look at the petition...
The administrative aspect has to be...
Now, the question therefore arises, my lords, that once two villages say that we do not come under their jurisdiction, and since 1957, my lords, this society has been doing the local administration. Now, we would again have to go back to the constitution, my lords, of right of self-governance as subordinate authorities, and my lords, having recognition from the state. The state recognizes us, the state has given us authority. Now, whether that can be, my lords, circumscribed by the district council by issuing a notification saying that you will have to be merged with a certain district council is the core issue. And of course, my lords, that other issue would again then come in that even under the act of the district council, if a certain village is to be merged with another village, my lords, the view of the majority of the members of that particular village would have to be taken. Even under that, my lords, we do not come in. So unless that procedure is followed by the district council, my lords, whether there can be a unilateral order saying that henceforth you are to be merged with so-and-so, especially in view of the fact that there is an interim order operating of the, my lords, Guwahati High Court.
The history of it has to be...
I can place the facts before your lordships.
Because you see, you have to go back to when and how the
colony came into
being. We may not know all the details, legally or otherwise, but as laymen, we know how it came about.
Lordships.
It will be very interesting.
Because this land was purchased by the government of India, my lords.
Oh, it was purchased?
The land was purchased by the government of India, and under a scheme, my lords, the refugees from East Pakistan were, Bengal, my lords.
East Pakistan.
East Bengal, because this would be, my lords, somewhere in late early 50s.
Okay.
This is early 50s.
This was as a consequence of the partition or the Indo.
Partition, my lords, 1947.
Not the Indo-Bangla.
No, my lords. So partition.
Oh, partition.
Yes, my lords.
Then.
That is why, my lords, I had in another analogous matter submitted before your lordship, my lords, that the position would be similar to what is the position of Defence Colony and CR Park in Delhi. These are all settlements which the government of India had procured for the resettlement of the refugees who had then, my lords, by virtue of the partition, had migrated to India.
Well, what do we do with this?
Well, I have one difficulty because I understand respondent number 7 is not available, but your lordships would have seen in the newspaper reports. Now, certain NGOs and other extra government authorities, who have no statutory authority whatsoever, have now been going and creating havoc in this colony in the name of, my lords, this administration of justice.
We don't know about that.
You see, the law will take care of itself.
No, my lords, which is why I am before your lordships. What I am submitting before your lordships is, my lords, let the Rinja Dorbar come before your lordships. If your lordships so feel, my lords, that Rinja Dorbar is a necessary party, let them come before your lordships. But till then, my lords, the position as is existing today, let that position maintain. Whatever is the position, my lords, your lordships.
That is not necessary. No, not necessary to be. No.
My lords, the difficulty is that now the district council is insisting on compliance of that particular notification. This was not happening till, my lords, a couple of months back.
When there's a proceeding before a court, how can they do that?
Your lordships must just clarify that.
I don't see any.
My learned senior may advise the district council.
I didn't see any letters, anything. I asked my colleague whether there any direction in black and white. He said no.
My lords, they are smart.
Not smart.
They are smart enough to know.
There was another round of litigation on this trade license issue. My colleague, I think, was the counsel in that case.
And there the district council ultimately had to bow down and give the trading licenses.
No, you submitted to our jurisdiction and we issued trading license.
No, not in this matter. Those were from Polo.
Yeah. No, I'm saying of RR Colony.
No, RR Colony is this matter where your lordship's orders are there. I am not disputing, my lords, the jurisdiction of district council because para 20 would come in. But the question is, who would be the local authority? You have to operate under a local authority.
But my colleague some time back was saying that can we be pushed to be under autonomous district council some time back?
No, I was not saying that. What I was submitting is probably, I could not clarify myself. What I was submitting before your lordships is that once the two villages say...
If I can understand correctly, it is only on the, let's put it this way, only on the issue of the self-government,
self-government, the local authority.
Issue of the local authority.
Lordships.
As to who would have, predominance, whether it's the Dorvashno or you on your own.
Lordships.
Or the district council.
Lordship. No, we are both subservient to the district council, my lords. We are subservient to the district council. I am not challenging the authority of the district council.
What you are saying in a sense is that you want to exist parallelly.
No, I am to exist under them. Because what had happened is, my lords, there was this meeting of all the stakeholders, including the district council. Now, the Rinja Dorbar says, my lords, you do not come within our jurisdiction. Umpling Dorbar says, you do not come within our jurisdiction. So, it was unanimously decided that this particular colony would have its own independent identity and those functions would be, the local authorities' functions would be dealt with by the welfare society. Government gives us recognition to do that. The birth certificates, my lords, the government has given us a letter saying that you are the competent authority to issue the birth certificates. All those authorities are there. Yes. Now we've been exercising that authority. Now all of a sudden in 2019, a unilateral order is passed by the district council saying that no, you are under the jurisdiction of Dorbashnong Rinja. That is the issue.
Has the Dorbashnong filed any affidavit?
They filed an affidavit. They filed. Pleadings are complete in this.
We'll wait for them. We'll give them another opportunity, or the parties, are requested to, at least try to inform them. This matter is pending.
We'll do that.
We have, in fact, the court has requested the previous counsel
to no avail.
Feign ignorance. Whatever the case may be.
No, they are a necessary party, my lords. I do not dispute it. They are a necessary party. My only grievance is, my lords, that till your lordships are seized of the matter, your lordships are hearing the matter. Let, my lords, no third party unnecessarily create a situation which is leading to some...
At this stage, no interim order.
Of course, again another...
We'll hear the matter ultimately. It can be a week, hence it doesn't matter.
We will see to that.
I'm sure my learned senior is here, my lords.
Not putting it in writing or anything, but I'll see to that.
Mr. Kanta, in the meantime, you
I know.
ensure, you ensure, on your own account,
I know,
that no coercive action is taken, so that it will not create unnecessary, dispute or problems.
Because, my lords, then what happens is dispensation of justice goes for a toss.
Actually, some NGOs came forward. We have declined to entertain them. We don't allow them to come in the picture, Your Lordship. We know our job, Your Lordship.
Which is why I said, my lords, we are in safe hands. My learned senior can probably put in a word.
No, we have done that. We have done that. We don't permit NGOs to do our job.
Even at this stage, it appears that the respondent number 7, public, Darvashno Rinja, has failed to appear for this court. The learned counsel's president has, however, submitted that the presence of the said respondent is required, as they are relevant parties to the list. Though on paper, respondent number 7 is deemed to have received notice. However, for ends of justice, this court would once again allow the respondent 7 to be duly represented. Then counsels herein are learned counsel of the parties herein are the parties here, parties appearing for this court today are requested to inform the respondent 7 of the pendency of this matter. So when do we fix?
Would have it on the week starting the 9th, well, it's 9th or 10th, subject to your lordship's convenience.
Of October?
So we'll have it on.
I'll try to suggest after Puja, Your Lordship.
Well, that's my difficulty I have expressed before your lordships.
That will see to it, Your Lordship.
Lordships may have it on the 10th, just for the purposes of service. And thereafter, because by then, something more.
Yeah, they might come and say new counsel will come and say I've just been given the brief and something like that will happen.
10 for that, I've suggested that let a copy of this order be. I've just suggested.
For the service part, my lords, let it be on the 10th, and thereafter your lordships will fix a date for you. As I'm sure, my lords, new counsel will not be able to argue this matter at one day, and this would require a little detailed deliberation.
True. This is matter on 10th.
10th. Obliged.
Much obliged and good day, Your Lordship.
Good day.